We will start first with our colleagues from the DGIP Indonesia. We would like to invite Mr. Noprizal, Assistant Deputy Director for Alternative Dispute Resolution from the Directorate of Investigation and Dispute Settlement from the DGIP Indonesia, to share with us the mediation service in Indonesia.
The Directorate General of Intellectual Property under the Ministry of Law and Human Rights of the Republic of Indonesia has the task of carrying out the formulation, implementation of policy of intellectual property and function and organism that provides guidance, protection, law enforcement, and dispute resolution, monitoring and evaluation, especially in the field of intellectual property of Indonesia. In terms of law enforcement and dispute resolution, the Directorate General of Intellectual Property has Directorate in Investigation and Dispute Resolution, Directorate of Investigation and Settlement of Intellectual Property Dispute. In carrying out its duties and functions, this Directorate provides in technical guidance for investigation, settlement of dispute of suspected criminal acts in the field of intellectual property, including judgment, patent, copyright, industrial design, layout of integrated circuit, trade secret, and trade varieties. This is number of intellectual property investigator and mediator in Indonesia. This is column. You can see this is a column. The role of the government in handling intellectual property in Indonesia in terms of providing instance of justice, comfort, and law enforcement in the field of intellectual property in science. The government makes and prime role including intellectual property law, government regulation on intellectual property, presidential regulation of intellectual property, regulation of Minister of Law and Human Rights of the Republic of Indonesia regarding intellectual property, government IPOPHL regarding intellectual property law in Indonesia. Number one, socialisasi and education of intellectual property to students and business actors. Number two, affordable, fast time and efficient intellectual property service process basis on online or offline. Number three, clear and definite law enforcement in Indonesia. Number four, affordable for and balance alternative dispute resolution. This is data on intellectual property case in Indonesia. This is maybe you can see this is a record. Okay, this is data on intellectual property violence of cases in Indonesia. This is total intellectual property mediation case of Indonesia from 2017 until 2021. This is data intellectual property mediation from 2021. Okay, mediation of the ethics mediation in Indonesia. Mediator, there is the independent, neutral, conflict or no. Intellectual property mediation mechanism in Indonesia. The disputing parties submit an application for mediation to the Directorate General of Intellectual Property. Number two, appointment of mediator. Number three, inviting the parties partially stake of mediation to publish initial information. Number four, the implementation of the mediation superior to two parties. The created the threshold of the mediation means. Intellectual property dispute resolution problem in Indonesia. Number one, there is still a lack of public understanding of the benefits of intellectual property mediation that is fast, cheap, and providing definitive legal certainty. Number two, there is still a lack of social and education on alternative dispute resolution in the field of intellectual property. Number three, there is still a lack of mediator who handle mediation cases because the Director General of Intellectual Property is more concerned with the investigation process. For the Director General of Intellectual Property, number one, conduction, society, and education on the benefit of intellectual property mediation in Indonesia. Number two, conduction, training, and guidance for new intellectual property mediator in 2001 and has finishing training in September about 250 participants. Thank you very much.
And for this sharing session, we would like very honored to have with us today Ms. Vilmi Quipit, our colleagues from IPOPHL to share with us for this topic. Ms. Vilmi Quipit is currently an international mediator of WIPO and a mediator of IPOPHL ADR services. Ms. Vilmi is also a Supreme Court mediator at the lower court under the Philippines Mediation Center for more than 2 decades now. She also conducts trainings and lectures on mediations at the Philippine Department of Justice and private institutions locally and internationally. Ms. Vilmi received the Peacemaking Award given by the Supreme Court of the Philippines during its centennial anniversary celebration for being an outstanding mediator. She was also the former executive director for mediation in IPOPHL. Ms. Vilmi, thank you very much for joining us today. The floor is yours now.
Good morning to the Europeans and good afternoon to the Asians. As mentioned, thank you so much for the generous introduction, Yung. I am so happy to see almost 6 of my colleagues in intellectual property in the Philippines who are with us in this webinar. Last week, Engineer Lewin de la Concha, the ADR Services Manager of Intellectual Property Philippines, spoke about the administrative details of intellectual property, especially the government decrees to support its establishment. So my task this afternoon is to share with you in 15 minutes how mediation is being conducted in the Philippines, its uniqueness, the best practices, and some challenges. Okay, just as what Guran and Alexandra mentioned, a mediator must be ready and prepared. In my case as the mediator, I have this mediator's dictum. I tell myself that I have to let my speech be always full of grace, seasoned with salt, so that I may know how to answer everyone, especially those who will come to me for mediation. Now, as we have heard many times, that mediation is a process of settling disputes between or among the conflicting parties with assistance of a trained, neutral, third party called the mediator. Therefore, mediation is an assisted negotiation. The roles of the mediator have been mentioned earlier, but I'm just sharing this because these are the 3 major roles we practice in the Philippines. That a mediator is a conflict manager. So I mentioned that the role of the mediator is that he or she is a conflict manager. And as a conflict manager, he is in charge of diffusing tension when the parties come to the office. It is a sign, it is a way of saying the mediator is in control of the situation, being an officer of the court. Now, the second major role is that the mediator is an effective communicator. As effective communicator, the mediator proactively listens and asks questions competently to the parties in order for him or her to be able to generate the interest of the parties. And the third major role is that the mediator is a process expert, meaning he has to skillfully bring the parties to the different stages of mediation so that the parties will be able to express their interests in the situation that they are in. Okay, now in the process, as process manager, the mediator actually goes through these stages. Actually, as we experience long in mediating, there may be some portions that will vary, but this is the regular stage of mediation that takes place during the mediation proceedings. So you see here the opening statement of the mediator, then the opening statements of the parties. And each opening statement, it is commendable that the mediator summarizes the opening statements of the parties in order for them to listen from a third neutral party concerning their own position and interest in the matter. And whatever takes place in their opening statements, these can be used in the agenda setting, which will lead to the exploration of issues. And if ever there are things that need to be spoken of privately, then a private session, a private caucus will be called for. After both parties or private caucus, they have to be brought together again for a joint session, hopefully which will lead to them in the crafting of the compromise agreement. So another, what is being practiced in the Philippines, just like what we heard from the European counterparts, it is interest-based. The parties are encouraged to see their dispute as a mutual problem to be solved by the parties jointly in order for them to look at their interests. When we say interests, we mean their priorities, their expectations, their aspirations, their concerns, their hopes, and more, which will lead to the parties finding their common interests. I have here the definition of what is position. Okay, position is what parties say they want, while interest actually is what caused the parties to say what they want. Another definition of position is that it is the claim, the demand, the posture, the stance of the party. And the interest actually is the reason or motivation behind their claim or demand or stance. Now, the mediator must focus not on who is wrong or right, who has a stronger or weaker case in the courts. The mediator instead helps the parties to move from their position to their interest and eventually to their shared interests. I would like to liken the position of the parties like the tip of the iceberg. Okay? Whereas the interest is the underlying issues that are in the hearts of the parties. Now, you see here that this is just a part. The interest actually is bigger. To explain further, okay, the mediator's tasks in mediating is, of course, we can see the part, the tipmost part serves as the position of party A and party B. If we focus on their positions, they never will reach each other. However, a skillful mediator in the course of the mediation session, implementing his rules, he can dig deeper into the interests of the parties. There are exclusive interests which may be conflicting with the other party's interests. However, the most important thing is that they will be able to find the common interests as parties in conflict. This common interest, another word for this, is the zone of potential agreement. Okay, I have one example in here of a case in intellectual property that I handled. It is a sample of a new band, musical band in the Philippines. I will just call the band Heaven Band, but it's not really the true name of the band. Now, when they came to me in mediation online, they agreed, okay, after much discussion, they found a common interest that both parties would want to benefit from their trademark. It's a trademark, it's a petition for cancellation of the trademark. So they said, okay, we would like to benefit from the mediation, from the trademark. So they thought of how to benefit from the trademark, and this was the compromise agreement they reached. They have actually two registrations. It's for Class 25 apparel and Class 41 for performance. So the parties agreed that the respondent registrant will transfer all his rights to the three petitioners on January 1, 2025. And the responding applicant will no longer use the mark after the assignment of rights. So we notice here that if they took the pains of going through litigation, they won't be able to finish it quickly. Actually, we met 4 times within the 60-day period, and the agreement was reached. In our meetings, we met about 30 minutes to 1 hour, and then we set it for another day because they would have to think about the offers given by both parties. In the Philippines, our practice is, it is mandatory for the contending parties to go through the process of mediation. However, the decision to enter into a compromise agreement is voluntary on the part of the parties. So the voluntariness happens in their decision whether or not to enter into a compromise agreement. That one is patterned after the Supreme Court rule also of having to mandatorily require the party litigants to go to the mediation office. Another unique feature in IPOPHL, the mediators have zero knowledge of the merits of the case brought before them because the parties are not required to submit their position paper. However, the mediators are not prevented from going to the originating office and reading the pleadings of the parties, the complaint and the answer. But we don't normally do it. So the mediator has to really be the one to elicit competently from the parties their interest after we have moved them from their positions. Other related cases involving the same parties may be included in the compromise agreement as long as the parties agree to it. The case that I handled that's the longest being settled in intellectual property was a 20-year-old case and was settled in IP within the 2-year period, including the cases that were filed before the Court of Appeals of the Supreme Court of the Philippines. So Alexandra mentioned earlier that this type of a problem will best be resolved in mediation because all the other cases can be put to rest having to use the mediation style. The confidentiality of information, it is a very attractive feature in mediation that encourages the parties to open up and be willing to negotiate with the assistance of the mediator, as anything talked about during mediation cannot be used against each other in court. So they feel free when they understand that what is being talked about will remain in the four corners of the room. Another unique feature is that the principal parties are represented in IP, represented by the counsel, by the respective counsel, instead of the principal parties appearing during the mediation proceedings, as most of them are based in the foreign country. When the court or the Board of Legal Affairs or the Director General renders his or her decision based on the compromise agreement submitted by the parties, such judgment becomes final and executory, therefore they are non-appealable anymore. Another one is that when the case is settled and the respondent complies with his or her obligation, it has the effect of a clean record on the part of the respondent, as if no case was filed against him or her. Earlier on, there was a mention about an impasse or a dead end in the negotiation. This will be the best time for the mediator to call for a private session, one-on-one with each party, for the purpose of trying to discuss privately with each of them to offer a possible last acceptable solution to their conflict. This is not being practiced in the court. However, in mediation, we can just readily avail of such technique that is allowed to be used in order for the parties to reach an agreement. Okay, those are just a few of the unique features that are done in the Philippines. The best practices in the Philippines, there are 16 mediators, IPOPHL mediators, and 9 of these mediators are process experts, and 7 are IP practitioners who are experts in their field. So because the IP process experts lack knowledge in intellectual property rudiments, we teach each other. That the process experts teach the IP practitioners the skills and techniques needed to become effective as a mediator, whereas the IP practitioners teach the process experts the rudiments of IP in order to understand the case brought before them. So this is one practice that we really appreciate so much, that we work as a team in order for us to really promote mediation in intellectual property. Now, the IP lawyers have become our friends. So when they become our friends, it will be difficult, and they're ashamed to make things difficult for the mediators. So in mediation, you gain friends. They show us their cooperative spirit and they support mediation because they're our friends. Now, mediation fee is very reasonable. For 4,000 pesos per party, this entitles the parties to avail of 4 sessions of 1 hour or less per session. So the sessions are short, but very cordial. Also, one best practice is that the party litigants are treated with utmost respect. So in IPOPHL, the mediation room is so conducive to talking with the demeanor and manner of the mediator and the soothing voice of the mediator. So we make it a point that the mediator handles them in a manner that will create a good ambience in the office. Mediation is resolved quickly as the procedures are flexible and not regimented. More so if the parties are cooperative. So it is quickly resolved and it is less costly. That's one advantage really in going through mediation, especially if the case is settled. So the mediators find deep satisfaction in seeing parties relieved of their burden from court litigation. I experienced personally and see how relationships have been healed and restored, and a number of cases settled with the parties when the parties see the perspective of the contending party with the able guidance of a trained mediator. So both parties feel that they have won their case. The challenges that we experience, one is that unlike the court-honest mediation, where the success rate is 70 to 80%, we have a much lower success rate. Now, it was mentioned earlier by Alexandra that success in mediation is dependent on the parties themselves. Therefore, if ever it failed, it's really because the parties didn't want it. But we're trying to look deeper into the reasons for it. And in our discussion, the last meeting we had with the management of Intellectual Property Philippines, one of the things that we noticed was maybe it's very important for the principals to join us during mediation so that they can see the winner of the contending party, and that might explain the doubts that they have. They might answer for the doubts that they have in their minds. We really desire to increase this. So that's one of the challenges that we're facing. And we encourage, I don't really know how to engage the principal parties to join in mediation considering that there is a time zone difference. And then also, maybe you can consider EU IPO and ASEAN, how to reach the international stakeholders of IP to join us in an international webinar like this, will focus on giving weight to the value of mediation in their businesses, because they surely will benefit from it. So maybe the EU IPO and ASEAN can include this in their future webinars. I have chosen to continue to mediate because mediation is really my passion. Because of the Ministry of Reconciliation that goes with the vocation. And I'm so happy to be doing something that I know the God I serve is happy about. Because he said in the scriptures, blessed are the peacemakers, for they shall be called the children of God. Thank you.
Yes, thank you very much, Ms. Vilmi, with your sharing of the operation and challenges of IP mediation service in the Philippines, as well as your nice quote at the end of your presentation. So now we will move to the Q&A session of our last topic. We have received some questions, and I would like to invite both Mr. Noprizal and Ms. Vilmi to join us for this Q&A session. First is some questions for Ms. Vilmi. I think there are two questions. I think the first question you already mentioned in your presentation regarding the success rate. For the second questions, you mentioned in your presentation that IPOPHL mediator work as a team. So normally for one mediation case, how many mediators will involve in the case? Can you have to share with us?
Okay, for the success rate, this was mentioned by Engineer Luwin de la Concha last week. It was less than 40%.
Okay.
Yes. When we ask the part, especially the lawyers who represent their clients, they say, well, our principal has decided to terminate the mediation. And when we ask for because of business reasons, they're trying to protect, all that. We tried the best that we could, but mediation is, in terms of success, reaching a compromise agreement, it's voluntary. So there's just so much that the mediator can do.
Yes.
And the second question is, IPOPHL mediators work as a team. Normally, normally for one mediation case, how many mediators will involve? No, we do not practice yet the co-mediation. We handle the case alone as mediator. Maybe in the future, when there will be many parties involved, we might employ that. But for now, since only one representative from the petitioner and one representative from the respondent, or at most 4, then there's no need yet for now to have co-mediation. I hope I answered the question.
Yes, thank you very much, Ms. Vilmi. Yes, it's clear now. The next question we received is from Mr. Noprizal from the DGIP Indonesia. Can you share with us the mediation fee in your office, and also the same questions, what is the success rate of mediation in your office? We would like to ask Mr. Noprizal if you could have to answer these questions.
Baik, terima kasih. Tadi sudah
Thank
sampaikan
you.
ada dua hal yang
I have mentioned our accomplishment and related on the mediation fee. This two item is our concentration in the DGIP. Our officer is very limited. We do not burden any fee to any parties. So it is free for all parties, and the government will pay for that. And related to the success rate, until now, we have 70% of success rate. During the mediation, the difficulty is we find it difficult if we have a case between two companies, because they are the CEO and other parties that have the authorities to have decision. But if the case related with the copyright or patents owned by individuals, the process is faster. Maybe I can answer for your question.
Yes, thank you very much, Mr. Noprizal, for sharing with us the mediation fee and the success rate in your office. I think we received one last question from the audience, and it could be the last question of our session to date. I think this question is also related to the topic 1 and topic 2 delivered by Alessandra and Goran. So if Alessandra and Goran, if you would like to chip in and share your view for these questions. After signing the settlement agreement, the parties are under contractual obligation to perform the conducts. What happens if after signing it, one of the parties suddenly feel the terms are unfair and unsatisfied with the terms?
Yes, well, a settlement agreement signed by both parties is usually binding. So it will depend on the clauses that the lawyers typically have included in the settlement agreement. Now, what they might have included is that in case of a dispute, the parties may, for example, go to arbitration. It is very frequent that they include a clause whereby the parties undertake, for instance, to go to WIPO for arbitration, or they bind the settlement agreement to a concrete jurisdiction, and then the courts of this jurisdiction will have to decide on the contract. But it is a binding contract usually. It is a binding contract ruled by the civil laws, as any other contract between parties would be. So second thoughts after signing it normally does not lead to a renegotiation of the mediation. I mean, they can obviously contact again the mediator, and maybe the mediator is willing to try to talk to the other side. But I think once that the settlement is signed by both parties, it's enforceable. Maybe my colleagues have other ideas, as this is quite an international issue, right?
Yeah.
Yes,
well,
thank you, Alison. Yes,
I
please go ahead.
quickly just consider that I think this is precisely why we've outlined, or let's say highlighted a couple of times, that it's important and beneficial for the parties to be represented, particularly when it comes to the drafting of the settlement agreement, which is where the lawyer's duty is perhaps the most pronounced. And in that regard, they need to have the best interests of their client in mind when articulating the different terms and provisions of the settlement agreement. So again, back to my concept of the good lawyer, to what extent that exists in reality and is not only fictitious. A good lawyer would prevent such a situation from happening already at the conclusion of the mediation process. However, should it come up, yes, totally what Alexandra said, or there's clauses that define how any further conflicts would be dealt with, whether they're back to mediation or to another ADR, such as arbitration. That could be a route provided. Also on the actual dynamic of that particular case, if the parties somehow manage to create a good relationship during the mediation, they can just get in touch with one another and say, look, I find this unfair. Can we redo the contract? There's nothing preventing that from happening. And if none of that works, well, finally, yeah, like with anything else, your recourse is to have the contract reviewed by the court in the jurisdiction that you've elected for as the guiding law of the agreement. And there, if we're talking about unfairness, depending on the kind of unfairness, you have a bit more flexibility potentially in common law jurisdictions. I don't know if the colleagues from Singapore have anything to say on that, but usually certain terms of a contract can be read down if they're deemed by the court based on the case law to be unfair, meaning it would be the same as reading the contract, but without the unfair provisions existing. This is a bit academic, but it's an idea.
Yes, thank you, Warren and Alexandra. I think our colleagues from Philippines, Ms. Vilmi, please go ahead and contribute your view. Yes.
We are very fortunate in Intellectual Property Philippines because the compliance rate of the compromise agreement submitted is 100%. So we have not received any complaint. But in the court annex mediation, I have experienced that the lawyer who was present during the first session and absent during the second session was the one who made the complaint. But when I talked to the party, the principal respondent, the principal respondent said, well, ma'am, I'm really happy with the compromise agreement, only that my lawyer is unhappy. I'm not saying all the lawyers are like that, but we have some problems like that in the Philippines. Or one time there was a case with my other fellow mediator. The judge had them revise the compromise agreement, and then after that, it passed the judge, and the judgment was based on the compromise agreement submitted.
Yes, thank you very much, Ms. Vilmi, to share with us this practical case in Philippines. Dear colleagues, I think due to the time limit of our workshop today, we would like to close the Q&As as well as the workshop to date. We thank you very much for all of your questions and your participation in the workshop today.